all the good morning and good evening both, because we have a friends from USA where there is a morning, and in India it is evening. So it is both good morning and good evening to all the academician, participants, students. It's my pleasure to welcome you informally and formally. Will be welcomed by our Dean and Director in this panel discussion on comparative constitutional law. So I would request Puri Madam to formally welcome our all the dignitaries and guests. Over to Puri Ma'am.
Thank you, Dr. Takesh Molia, and good evening, friends. Good morning, Steve, and dear students, faculty, colleagues. We have a very distinguished panel today, and we are truly honored to have with us Professor Vijayakumar from National Law Institute, University Bhopal, Professor Carlos from Faculty of Law, University of Piura, and Professor Petar from University of Split, Croatia. The topic, the theme for today's panel discussion is very, very vital, and it's really vital in this truly globalized world. And we always learn from the best practices from different countries. And being a democratic nation, we have some shared concerns. And I'm so great to see that today Professor Vijayakumar is going to speak on importance of separation of power, which is so crucial for maintaining the rule of law and transparency in the governance. We also have Professor Carlos, who has agreed to speak on European and Latin American constitution. As a part of our LLM program and as a part of our constitutional honors course, we do offer a comparative constitution as a separate course, but having understanding from you on European and Latin American constitution would be a great value addition to our students. And we also have Professor Petar Bačić, and Professor Petar is going to talk on constitutionalization of the rule of law in European new democracies and role of constitutional courts. When we talk about the constitutional courts, we have observed in all the parts of the world that constitutional courts have been playing a tremendous role in upholding rule of law and maintaining the unique democratic values. So I, on behalf of Nirma University Institute of Law, wholeheartedly welcome all these three distinguished constitutional law scholars to this International Teaching Month. And we have, as we have mentioned in our posters, we always believe in our Sanskrit saying that let all good thoughts come from all the directions, let all noble thoughts come from all the directions. We are so grateful to all the distinguished panelists to share their ideas from different jurisdictions of the world. Thank you so much.
Thank you, ma'am, for welcoming all the dignitaries. Friends, today's theme, that is the panel discussion on comparative law, as Madam has rightly stated, is the most significant in the present era due to globalization. There is a conversion of all the legal systems, and the process of conversions can be conducted through a reason-based research methodology, and that methodology is an comparative method. As in science, we have experiment in the lab. Similarly, in law, if we want to experiment a various thing, it is through this method of comparative law, where we see the similarities and differences of the different legal systems of the world and see that how it can be converged, and inferences can be drawn which can lead to the universalization or generalization of the principle which can be applied globally. So in that sense, friends, those who have not studied the comparative law or who doesn't have a certain basic idea, for them I would like to give certain basic thing so that today's panel discussion will sound fruitful to them and they will able to connect the discussion. The comparative constitutional law is the study of differences and similarities between the laws of different countries. It comprises the study of different legal systems existing in the world, including the common law, civil law, socialist law, Islamic law, Hindu law, Chinese law, or alike. It includes the description of analysis, of foreign legal system, even where no explicit comparison is undertaken. In the present age of internationalization, economic globalization, democratization, the importance of comparative law has enormously increased. It should be remembered that comparative law is not a principle or body of rules of law, but an approach or a method or a technique of studying a law or any breach or topic of it arising from the multiplicity of legal system in the world and the different approaches adopted to common problems. By examining attitude, institutions or rules or any matter of any two or more legal system. Further, the comparative study is a valuable for parting the study of any one legal system into the perspective and developing the understanding of it. It is also invaluable for a jurisprudential studies for the nature, functions, and general ideas about the law. Now, without further delay, I would like to introduce you all to our panel, which comprises Professor Vijayakumar. Professor Vijayakumar.
I would appreciate if you introduce the foreign dignitaries first.
Okay, sir. With your, I would introduce our dignitaries. First is Hakansson. Hakansson is a lawyer and was a dean at School of Law and director of the Human Rights and Democracy Institute. He has authored a various books on the constitutional law, and he has authored several articles published in national and international law reviews. He is a professor of constitutional law at the University of Piura and Jean Monnet Chairholder, European Commission. I welcome Professor Carlos Hakansson. Another eminent speaker is Peter Bačić. Professor Dr. S.C. Peter Bačić is a full professor of constitutional law at the Faculty of Law, University of Split, Croatia. Professor Bačić is a member of Southeast European Law Schools Network, SILS, Management Board and member of Croatian Association for Constitutional Law. He is an editorial board member of SE Law Journal and of the SEEU Cluster of Excellence in European and International Law series of paper. Professor Bačić is an acting Vice Dean for the International Cooperation of Faculty of Law in Split. He was a member of the President of Republic Experts Commission on Constitutional Issues. Besides constitutional law, Professor Bačić also teaches European laws, human rights laws, as well as constitutionalism and judicial activism. He has written extensively on Croatian and comparative constitutional law and human rights, including several books and 40 scientific articles. His main research interests have been in the field of comparative constitutional and European public law, judicial activism, and human rights. I welcome Professor Peter Bačić. Professor Vijayakumar is the Vice Chancellor of National Institute, University, Bhopal, Madhya Pradesh, India. A graduate of Madras University, Professor Vijayakumar was a Vice Chancellor at Ambedkar Law University, Chennai from 2010 to 2013. He has also served as a registrar at NLSIU Bangalore from 2005 to 2008, and sir has published various papers in the reputed journal. I welcome you, sir, on this panel. I welcome all the guests on the panel, and now I would request Professor Vijayakumar to start with, and as Madam has already introduced the topic on which the Professor Vijayakumar is going to speak, and that is the importance of separation of power to the Constitution. I welcome you, sir. Vijayakumar, sir. Over to you, sir.
Okay. Thank you very much for the nice introduction. Good evening and good morning, and hello to everyone present on this virtual platform. I chose this topic for two specific reasons. One, this is one area where political scientists have done lots of work and lawyers have done possibly a little, particularly in this part of the globe, the South Asian countries. And therefore, I would like to present my views as to how important this doctrine is for constitutionalism to flourish, not only in South Asia, but in the entire Commonwealth, and if possible, the whole of the globe. My welcome to Dr. Jude Mathews, Professor Carlos, Professor Stephen, and Professor Peter. I would like to just be very brief because this is a topic where I spend hours together to discuss with my students. I raised lots of questions, asking them to come back with their findings and responses, through which it is possible both for the teacher to learn and move forward and point out the mistakes or the flaws wherever we see. In this regard, I would like to make this presentation based on three important propositions. The first proposition is the presence of the concepts of the doctrine of separation of powers and associated doctrine called checks and balances, and the way the courts and other branches have appreciated their presence in each and every country. That will be the first portion of my presentation. The second one will be that these two concepts provide for primary accountability. Right? I would like to emphasize on the primary accountability at two levels, internal and external within these organizations or branches. And finally, that the reasons for the failure to enforce the primary responsibility or primary accountability, and thereby the failure to realize the secondary accountability in the process of governance, whether it is East or West. And I would like to conclude by saying two examples, India and Sri Lanka, at the fag end, as to why I chose these two examples. Now, as many framers, many writers have mentioned this, Constitution is an instrument through which the legitimization of the authority of various institutions of the state, elected or nominated, takes place. If this is the case, the Constitution is a collection of ground rules or the Grundnorm of the government as well as the society. And therefore, we expect the Constitution should provide for the creation of the basic organs or the institutions of public authority in the first place. And secondly, it must define the powers possessed by each of the public institutions, and in some respects define the relationship among these institutions as well. Thus, a constitution assigns a legal responsibility, defines the limits of the authority, and establishes the process which must be followed before this authority can be exercised. Having said that, laying the foundation for the presentation, I would not like to go through what Montesquieu said. I think it's a wonderful theory that everyone knows about it, right? But the crux of his theory was very, very clear, that is applicable even to the 21st century, and it will continue to apply even to the 22nd century. Because the object of this doctrine of separation of powers is the preservation of liberty. And that's what Montesquieu very clearly brought out. If you allow two branches to come together, there begins the end of liberty. That's the wisdom this man had centuries ago. Now, the first country which tried to put it into practice is the US Constitution. And I would like to mention to my Indian audience who are present here to carefully look at the American Constitution. There are just 7 articles in the Constitution, and they have very neatly divided the power or separated the power at the federal level. The first article, article number 1, vesting the legislative power with the Congress and the power structure, how it has to relate or function with relation to the executive and the judicial branch, everything is mentioned therein. The second article vests the executive power with the president, and the third article vests the judicial power in the Supreme Court. So there are very clear divisions of executive, the legislative and the judicial power, or if I have to go in the same norm, legislative, executive and judicial respectively in Articles 1, 2 and 3 of the US Constitution. Now, if somebody would like to look at the presence of this concept or the doctrine called separation of powers and checks and balances in the whole of the Constitution, I don't think anybody will be successful because these phrases are seldom used. One has to go through the written provisions of the Constitution to come to the conclusion that there exists separation of powers as well as checks and balances. And this concept of checks and balances brings in the relationship among the three branches of the government, as well as providing the limitations that one organ can exercise over the other two, or at times two organs can exercise over the first one whenever it violates the jurisdiction or transgresses the jurisdiction. And therefore, I would call these two doctrines, concept of separation of powers as well as checks and balances, as twin sides of the power controlling mechanism in any constitution. And therefore, if one looks at the doctrine of separation of powers and searches for the phrase in the Constitution, either in the US or in India, I think they will fail. But I would like to define the concept of separation of powers under two broad categories. And that is the place, that is the root cause for misunderstanding of the importance or the significance of this doctrine of separation of powers. The first one model is the rigid model of separation of powers, which I also call it as watertight model. What does it mean? It means that there is separation of powers, there is executive power, legislative power and judicial power, but they are defined in such a compartmentalized manner, there is no relationship among the three. And therefore, such an arrangement in any constitution, east or west, cannot survive because the three branches will go in three different directions and the governmental machinery cannot move. It will collapse the moment they have the watertight compartment present in their constitution. On the contrary, is what I call it as flexible model or as the overlapping model, in which there is the concept of checks and balances that forms essential part of the separation of powers. So therefore, if one goes through Articles 1, 2 and 3 of the US Constitution, they can see how beautifully they have intertwined the concept of separation of powers with checks and balances, clearly informing the authority, this is your limit, this far and no further. And if you try to do it, what will be the consequence? I think very beautifully defined in the federal constitution of the US. When you come to the Indian Constitution, we have the lengthiest constitution in the world. Of course, it covers both the federal constitution as well as the constitution for all the states. And therefore, it is inevitable that the document is a lengthier one with 395 articles and about 12 schedules, and the constitution itself has been amended about 104 times in the last 70 years. So one is mind-boggling to see how this constitution has survived and continues to survive and able to perform better relatively when compared to the other South Asian countries. Recently, what has happened in Nepal is a very good example, where the parliament was dissolved and now the judiciary has brought it back alive by reconstituting the parliament, the legislative body. So therefore, one can understand that by going through the provisions alone, one can understand. Unfortunately, or fortunately, people seldom understand the values of the phrase constitutionalism, which brings diverse values and gives life to the words of the Constitution. And that keeps the Constitution alive and kicking in every country wherever it is successful. So therefore, constitutionalism comprises of various values, and one such value is what is also being discussed, the constitutionalization of rule of law by Petar. So therefore, one can understand if rule of law is one such value for constitutionalism, I would put on the equal footing separation of powers and checks and balances would also form part of that constitutionalism, that value which constitutes the constitutionalism. Having said that, I would like to very quickly take you through what has happened in India in the last 70 years. In the very first year, the Supreme Court had an opportunity to make an observation on this doctrine of separation of powers. That is, very first year of the commencement of the Constitution. The 7 judges who presided over the court in 1951 very clearly said that we don't have any specific concept of separation of powers under the Indian Constitution. I really do not know whether they had the time to go through the Constitution in detail because it's the first year. But it got reflected time and again until 1973. The Supreme Court did not accept the presence of the doctrine of separation of powers under the Indian Constitution. And therefore, one branch became all-powerful, sidelining the other 2 branches. And some of the problems that were created in the constitutional governance in this country are due to this particular confusion that was created. In many cases decided by the Supreme Court up to 1973, they went on to say that we do not have the doctrine of separation of powers like the American Constitution. I would like to just paraphrase this. We do not have separation of powers like the American Constitution has. And that's why I made a mention that separation of powers is not mentioned specifically. So one has to go through the text of the Constitution to understand. And therefore, the same thing applies to the Indian Constitution. Nowhere the doctrine of separation of powers or checks and balances are mentioned in that form. But let me tell you, there are plethora of articles which provide the executive power, the legislative power, and the judicial power at the center and the states very clearly, and also the relationship among the 3 branches, very neatly done. I can give you, series of articles, not one. But still, the Supreme Court went on to say that we do not have the type of separation of powers that the American Constitution has. This is the place where it is also the weakness of the comparative constitutional law and also the strength that we need to build to make the people understand that it is the to the credit or to the advantage of the people to safeguard their liberty that there shall be separation of powers. And therefore, the courts, whatever they said between 1950 and 1973, got a little bit diluted to the Supreme Court going to the extreme end, the entirely different opposite conclusion. 4 judges of Keshavanda Bharati's judgment very clearly mentioned that separation of powers and checks and balances are the basic features of the Indian Constitution. See, up to 1973, they never accepted it. And 1973, 4 judges of the Supreme Court who decided this case, Keshavanda Bharati's case, they very clearly said that separation of powers and checks and balances are the basic features of the Indian Constitution. Therefore, basic structure or essential feature in whatever language we understand. Now, what did it entail us? After 1973, there are many decisions which I don't want to narrate all of them, starting from Minerva Mills case to the state of Kerala and the state of Tamil Nadu, right in 2007 or 2008. The Supreme Court has been telling the same thing, that there is separation of powers, but this separation of powers is limited only to protect the court from the other 2 branches, but it seldom recognizes the existence and the importance of the other 2 branches. Right? That is the place where I think the judiciary has been going wrong in this direction, and therefore we do not have separation of powers in practice, though the Constitution crystal clear enunciation of these 2 concepts in various constitutional provisions, not one. There may be more than 70 articles which speak about the interrelationship, but we have not read any one of them. And therefore, we continue to trumpet that we do not have separation of powers, and therefore one branch is much superior to the other, right? This has led to what you call it as some amount of chaos and confusion. in transition of power from one government to another, so on and so forth. And I will not get into the details of that. If this is true, I also wanted to flag another important aspect. India is also part of the Commonwealth organization, Commonwealth countries. And as part of this, there was some development that took place way back in 2003, where the Commonwealth countries adopted a principle called as Latimer House Principles on separation of powers, the three branches very clearly. And the agony is that the law minister of the government of India was one among the lead members of this conference among 8 who drafted this. And they drafted it so very well. And that did not get translated into action in India, like in any other Commonwealth countries, because it happened only in 2003. By the time it percolates down, it may take another decade or so, right? And therefore, the Commonwealth countries came together and also planned something else called as Edinburgh Plan of Action for the development of promotion and implementation of the principles of accountability and the relationship between the three branches of government held in Scotland in 2008. Now, this plan of action from 2008, still many people, scholars in India, and of course the judges, possibly do not even mention that in the judicial decisions. And therefore, there is a wide gap between what is happening in comparative constitutional law to accept even the Commonwealth countries' principles, enunciated principles in the form of Latimer House Principles, as well as the Edinburgh Plan of Action. And even now, the courts keep on saying that the courts are independent, courts have all the powers, so therefore there is separation of powers. It is only one way. What about the other two? Let us discuss and continue to discuss. Now, let me just conclude because my time is up. The 20 minutes allotted, I should not take more time. Let me come to the conclusion. I was addressing around 45 senior counsels from Sri Lanka at the National Law School, Bangalore, where I was a founding faculty member. I was a course director for some of these training programs. And when we were interacting, the leader of this party of 45 senior councils, state councils from Sri Lanka, we also discussed about the form of government. And they very clearly said, sir, if given the opportunity, we would like to shift to the parliamentary form of government that India has, because they are tired with the presidential form of government, which has given so much of power to the president, whoever it is, whichever party he or she belongs to, and therefore they have killed parliamentary democracy. That is their view. I think everyone has the right to hold that view. And this is what they were saying. We are eagerly looking forward to shift towards the parliamentary form of government, India, and therefore the democracy can survive in Sri Lanka. Very quickly, I retorted and said, gentlemen, I also would like to tell you something. As an academic, I also eagerly look forward to the presidential form of government that you have in Sri Lanka, but with limitations, with all constitutional limitations, so that the president cannot become a dictator. And that is how the democracies can survive. Now, these two examples of what has happened in Sri Lanka over a period of almost the same extent, right, 70 odd years, like India, and ultimately we are still countering the question, what form of government that we require. And let me tell you, whether it is presidential form of government or parliamentary form of government, there is nothing wrong in the form of government. Unless and otherwise, we have the checks and balances among the three branches of the government to nudge each other within the functioning authority and also protect the rights and liberties of the individuals. Let me tell you, neither the parliamentary government is good, nor the presidential government is good, right? I think the US in the last couple of months, made it look that the president was becoming a little more authoritative, right? Violating or throwing away all the constitutional norms. And therefore, there may also be thinking on how to limit this power, particularly during the times of transition. He went on to pardon so many people, during the last 1 month of his office? Can that it be done? These are all the questions that one can throw, but I think we need to learn a lot from the practices, and that there lies the merits of the comparative constitutional law, to which I would once again appreciate the initiative taken by Nirma University and for aligning 4 experts from abroad. And I would once again request all the members, please do not treat this as a virtual meeting and end the relations, right? Like what the 3 organs have done among themselves. But I think we would like to look forward, and we welcome all the panelists to visit India at the earliest as and when the conditions improve, and also teach at not only National Law School in Bhopal. I am also one among, I was a former president of the consortium of the National Law Universities, all the 23 law schools put together. And therefore, you can also get a field of visiting any number of law schools that you would like to. By welcoming all of you once again, I thank the organizers for giving me this opportunity to share a few thoughts on mine on this particular very crucial, which I consider as very crucial. Thank you very much.
Thank you, Professor Vijayakumar sir, for enlightening us on the separation of power and need and necessity of having separation of power and check and balances. Once it was asked to Nani Palkhiwala that whether the India should switch from parliamentary form of government to presidential form of government, the same question which you raised, and he responded that the success of any system depends upon the person who operates the system and not on the system. The system might be the best. If the person is the worst, the system becomes the worst. And if the people are good, the system becomes good. So rather switching and experimenting a new form of government, rather we should identify the loopholes, as you have rightly stated, and plug those loopholes to make it more success. And that is that loopholes are to identify the check and balance and that separation of power. We would definitely take this as a further study of research under the comparative law. Thank you, sir, for your insight. Now I would request Professor Dr. Carlos Hakansson, former Dean School of Law, University of Peru, and his topic is European and Latin American Constitution. Professor Carlos Hakansson. Well, over to you, sir.
Sir, you are muted. You will have to unmute.
That's okay. Good night, India. Good evening, Europe. Good morning, America. Dear Professor Pardi Pokanharia, Professor Tarkesh Molia, and Professor Sheila Shrivatastava, dear my brother Steve Barnes, dear colleagues around the world at Nirma University, and namaste. A long time ago, on an island so far, we found the reason for all liberties, the rule of law. The British Magna Carta recognized personal freedom, and that was the first step to identify other kinds of rights and liberties on the European continent. Besides the United States independence, the French Revolution was the place of the principal diffusion of liberty, freedom, equality, and fraternity, were the main principles of the new order. The modern European constitution were finished the Second World War. German Grundgesetz on 1949 will be the model for other written constitutions like Spain, 1978. France chose a semi-presidentialism to his Fifth Republic, a French president with real powers. What's the main characteristics? First of all, the parliamentaries with control to get governability. Name it like a rationalized parliamentarism. a generous Bill of Rights and recognition of human dignity, no? In German, Poland, and Spain. No? Then a Constitutional Court of Justice. No? Constitutional Court of Justice, for example, the German Federal Tribunal, no? It's the best tribunal in European continent. No? Except France, territorial distribution of powers, like federalism in Germany, and like a asymmetric federalism in Spain. In the 19th century, Latin America begins the constitutional experience. First, with the Cadiz Constitution on 1812, with an important French influence in the French Revolution. Presidentialism was the main influence in Latin America forms of government than the federalism, only in Mexico, Argentina, and Brazil. The main characteristics in Latin America Constitution are these. No? First, the style of change constitutions once and again. No? Written constitutions were born to be reformed. Amendment, not to change it. No? Latin America Constitution are written in detail. No? Have around Latin American Constitution like have around 300 articles. No? And in practice, in fact, no rule of law. No, it's a rule of law crisis. No, except exception is the Chile, Costa Rica, and Uruguay. No? What about the development of Latin American Constitution? We can see 3 moments. First moment, we can see the independent processes at the beginning of the 19th century. No? Cadiz, French Constitution, American Federalist, and presidential form of government. No? The first moment to influence. No? Cadiz Constitution, again, only one option in Latin America, a republic. The sovereignty theory, no? Guarantees, but not a formal Bill of Rights until 18th century. Presidentialism without federalism. Presidentialism without federalism, in exceptions, Argentina, Brazil, no? Mexico. No? The second moment is the modern constitutions, like Germany, I say that, France, no, 1958, Italy, 1957, Spain, 1978, no? Modern constitutions like a consequence of the Second World War, no? Our constitution is, in this second moment, we can see a constitution is a supreme law, yes, but before a consequence of a fundamental agreement, no, between governments and citizens. That's not clear in Latin American Constitution. The only thing that the Constitution is a supreme law, no, like a supreme law of the land, like the states. But the core is important to know, because the Constitution is a consequence of a fundamental agreement between governments and citizens. No? Second, the human rights treaties with direct enforceability. No? The Universal Human Rights Declaration, the American Convention, no? Are 2 examples. The International Organization for Human Rights Protection, no? is other thing. A constitutional courts, no? Inside or outside the judiciary system, no? In the States, is inside the judiciary system, the Supreme Court, no? but in Peru it's outside, no? It has autonomy. An economic chapter in the constitutional text, no? To defend the economic liberties, no? Is other characteristic. That's the second moment. The third moment, they denominated like 21 century socialist constitutions, no? Like Venezuela, 2000, Bolivia, 2009, and Ecuador, 2008, no? The core of any constitution, I repeat, is an agreement to recognize rights, liberties, and to limit the political power. No? There is the main difference between Latin American and European constitution, no? Because Latin America defines it only as a supreme law, I say. The main characteristics of this kind of constitution in Latin America, I will explain in two parts. First one, about the principles and the fundamental rights. No? Bolivia and Ecuador introducing like Andean concepts like sumac causai, Quechua, or sumac camaña, no? Aymara, no? Which means like a welfare and harmony, no? Between natural resources and the environment, no? Means the welfare and harmony between natural resources and the environment, no? His preamble declares the Pachamama, no? Like the mother's nature, no? The mother's nature. You can see it in the Ecuador Constitution, 2008. No? All the Latin American constitution recognize international human rights, no? Human rights courts, no? But in fact, with reference to the Inter-American Court and his left ideological point of view. The direct enforceability of the International Court of Human Rights jurisprudence is named now like a conventional control. No? The American Convention is the conventional control. No? It's not constitutional control, no, it's not conventional control. No? A dialogue between the national and international courts. No? Now, written constitutions in Latin America declares a welfare state, but more than 50% of people pay private scholar and health services, public. Public services only used for extreme poorness. Now, Latin America Constitution have a complete Bill of Rights, a generous and complete Bill of Rights without an independent judiciary. No? That's complex. The habeas corpus is the most guarantee to personal freedom. No? It comes from the UK, no? But the amparo, no, created in Mexico, the writ of amparo, no, created in Mexico, was the Latin American institution to protect others' rights and liberties. No? What about political institution and separation of powers? First, the disbalancing of powers. No, a weak Congress, and a strong president. No? The main characteristic. No? A chapter of economics principles with the state like the main director of policies, no, an influence in the market. A written constitution of the 80s introduced the Swedish ombudsman. No, ombudsman is a Swedish concept, no, to control and accountability to public administration. No. Likewise, the presence of an independent constitutional court of justice. No? Chile, Colombia, Peru, Peru outside the judiciary, Mexico, Argentina, and Brazil inside it. No? the concept of rule of law is the main difference between Anglo-Saxon and European or Latin American constitutions. No? Anglo-Saxon, European and Latin American constitution use a German version, no, of Staatsrecht. It's a German concept. No? The Anglo-Saxon applied the same law and judiciary to all the citizens. Latin America has the regime administratif, like France. Functionaries have their courts and regulations, no? Different in the States or in UK. Then citizens first trial against the state with their tribunals and lawyers after that a judge knows the case. No? It's the main difference. Peru, Argentina, and Colombia have parliamentary institutions in their presidential form of government. The vote of no confidence, a prime minister named by the president, question time, are some of them, no? Parliamentary institutions. It's a mixture of presidentialists and parliamentaries. No? We see it in Peru, mostly. We see some of them in Colombia and Argentina. No? The presidential form of government is a consequence of a real distribution of territorial power. Federalism, for example, no? In Latin America, in Latin America countries, have a unit state, no? Except Argentina, Brazil, and Mexico, I say, with several problems to work in order. Latin Americans chose civil law, no? But constitutional courts create the judge-made law. No? Now, today, constitution courts in Latin America create a young but progressive common law with judiciary precedents, like Peru, Colombia, Argentina, and Chile. But it's in progress, no? Now, but it's in progress, no? With some problems to have a real Staatsrecht on rule of law. This is my point of view about the Latin American Constitution. Thank you to the Nirma University for your kind invitation, and to my brother Steve Barnes to contact and introduce me to you. Thank you very much. Namaste.
Thank you, Professor Carlos Hakansson, for enlightening us on your comparative analysis about the Latin American Constitution and European American Constitution.
Thank you very much.
Differences and similarities, and what lesson further other can learn from these similarities and differences. Thank you for enlightening us on this. Now I would request Professor Peter Bačić, Professor of Constitutional Law and Vice Dean of International Cooperation, Faculty of Law, University of Split, Croatia, and he is going to enlighten us on constitutionalization of rule of law in European neo-democracy and role of constitutional court. Over to Professor Peter Bačić.
Thank you, Mr. Chairman, dear colleagues, dear all, wherever you are. It's such a pleasure to be here among you today. And thank you, Professor Puri-Pokaria, for inviting me. Thank you, Professor Steve Barnes, for getting us all together, for introducing us. Okay, the topic of my speech today is constitutionalization of the rule of law. What I basically try to do, I just try to highlight the importance of the rule of law principle in general, but also to very briefly describe basic features of constitutional review systems adopted in countries of Central and Eastern Europe. I'll try to explain just some reasons that lie behind such their constitutional choice. I will also very shortly refer to systems, review systems developed in countries of that formed after the breakup of Yugoslavia. And I finally try to shed light on the role of Constitutional Court of my homeland, of the Republic of Croatia, in that process of democratic consolidation and overall building of the rule of law. So yes, the principle of the rule of law is a key principle of the international legal order. It is firmly embedded in essential constitutional documents of the international community, both at the universal as well as at a regional level. At the universal level, for example, the rule of law is embedded in the UN Charter or the Universal Declaration on Human Rights. At regional level, if we consider only European perspective, then we have the European Convention on Human Rights, which embeds rule of law already in its preamble. Same goes for constitutional documents of the European Union, namely Lisbon Treaty, as well as EU Charter of Fundamental Rights. So rule of law is a constitutional value on which the European Union is founded. But it is also one of criteria for accession to the European Union. And we might say that, well, it is a core element of something that we might call European political identity. Now, the same principle also undoubtedly forms the ethical concept upon which a vast majority of modern constitutions are based, but its constitutionalization has particular importance for newly formed states. Now, that was very evident in the case of the so-called new democracies of Europe. In other words, these are ex-socialist countries of Europe, so former socialist countries of Central and Eastern Europe that whose complete economic and political transformation began in 1989. And that transformation was primarily seen in radical constitutional changes. Namely, in that process of transition to democracy, which ex-socialist countries of Europe have been going through by the end of 1980s, beginning of 1990s, there were three prevailing ideas in that process: constitutionalization, human rights, and rule of law. Now, all of these countries were supposed to build a new society. All of these countries were supposed to make what we might call a decisive step towards the establishing of democratic institutions. Now, the starting point in the process of acceptance of these new values was the adoption of constitution. And insight into the constitutions of Central and Eastern European states clearly illustrates that new constitution makers overwhelmingly accepted concept of the state based on the rule of law. Exactly that Rechtsstaat, the German principle Professor Hakansson was mentioning. So, in fact, large majority of these constitutions explicitly refer to the rule of law or to the principle of a state governed by law. Now, in the sense of the fundamental value of constitutional order or governing principle of the state, rule of law is explicitly mentioned in all constitutions of all former Yugoslav republics. These are now independent states of Croatia, Macedonia, Bosnia and Herzegovina, Serbia, Slovenia, and Montenegro. But of course, the same goes for constitutions of almost all Central and Eastern European states. We could just name some: Czech Republic, Slovak Republic, Hungary, Romania, all Baltic states, etc. However, incorporating such provision into the constitution was the easy part, but the real challenge was to provide for its realization. Those citizens strongly supported breakup with socialist ideology. Political legitimacy of new regimes considerably depended on creating confidence in public institutions. In other words, ensuring that all political actors obey the constitution, trying to retain their actions inside the constitutional limits. That were crucial preconditions for the success and also for the acceptance, both external and internal, of these new regimes. So the limits of legitimate exercise of power had to be partly, of course, defined through interpretation of the constitution. And that is why an essential part in that process of constitutional transformation, process of upholding the rule of law, had to be played by the judicial branch, but especially by those courts that have power of judicial or constitutional review. I won't make any difference now between judicial and constitutional review. As you will see, almost all new democracies of Europe have accepted the same constitutional review model. That is the model that is usually called European centralized model. Now, according to classical approach to constitutional adjudication, there are two main systems. One is centralized or concentrated, and the other one is decentralized or diffuse system. In decentralized system, all courts are entitled to engage in constitutional adjudication of particular cases or controversies. In other words, all courts can resolve constitutional issues if, of course, such question appears before them in that conventional litigation. Judicial review, in that sense, is ordinary activity of the courts. And that model is usually known as the American one, as it was developed in the United States after famous Marbury versus Madison 1803 case. And of course, it has further been accepted in many countries with common law system. On the other hand, if the power of constitutional review is by constitution exclusively vested in just one body, in just one organ, and that organ is in most cases called a constitutional court, it is in most cases excluded from judicial branch, then such system may be regarded as centralized system. Of course, such constitutional courts are usually also empowered to examine statutes in abstract, meaning it has erga omnes towards everyone, erga omnes effect. So that model is often very described as the European constitutional review model. Of course, if we would go now in details, we would see that there are many variations between judicial review systems among countries of Europe. Of course, that there are European countries that follow decentralized models, such as Denmark or some other Nordic countries. We have, of course, UK and Netherlands with parliamentary sovereignty principle. That's something completely different. But and yes, maybe I should say the American system is not at all exclusively limited to countries with common law systems. But leaving that differences aside, of course, this distinction is notably European American, is far from being definitive, it's far from being precise, but it is useful for the purpose of this discussion, because in the process of post-communist transition, the similar system of judicial review was almost universally accepted. Now, what made this particular model so popular for these countries? There are several reasons lying behind such constitutional choice. One, of course, is obvious. It is strong wish of these countries to join as soon as possible the club of developed Western European democracies. How? Well, one way is by transplanting their institutional design, and that institutional design also includes constitutional courts as institutions that resolve constitutional issues and perform the duty of the guardians of the Constitution. Now, you probably know, I just say a few facts that about this centralized model. It was shaped according to influential normativist teaching. It was shaped according to Austrian legal theorist Hans Kelsen's model of constitutional court. And according to Kelsen, and only an organ which is distinct from the legislator and in the same time independent from all executive, and that is constitutional court, should be empowered to annul unconstitutional acts. So in that sense, the court exercises the function of negative legislator. Its functioning, of course, in that sense, does not include any moment of free creation. Creativity is exclusively reserved for parliaments as positive legislators. And really, such specialized institutions have been introduced first in Czechoslovakia and Austria. This was in 1920s. And, but real expansion of constitutional courts began only after the Second World War. And after 1945, similar institutions have been introduced all over Western Europe, beginning with Austria, then followed by Germany, Italy, later Spain, etc. Anyway, by the late 1970s, early 1980s, all Western European democracies had similar institutions of constitutional courts. But despite, of course, with some differences, but in spite of those differences, they all perform the duty of the guardians of the Constitution. Okay, as a consequence of all said, these institutions, these constitutional courts, remain outside the traditional division of power. They are usually seen as an independent, as an autonomous power, as sometimes it is described as a fourth branch of government. Now, due to its specific competencies, primarily through abstract and concrete judicial review, but also by protection of human rights through deciding on constitutional complaints, constitutional courts of Western democracies contributed considerably to consolidation and realization of democratic government. So they have progressively evolved from that narrow Kelsen's concept of negative legislator. They were vested with new powers. They steadily assumed the role of positive legislators. They started to take more active approach. They strengthened its position in that architecture of separation of powers. Now, over the years, some of those courts, especially German Constitutional Court, even Italian Constitutional Court, they have become very influential, powerful institutions capable of safeguarding the constitutions. And it was not surprising, therefore, that constitution makers of former socialist countries decided to follow that example of Western European predecessors. Now, the centralized European model of constitutional review with certain variations was in the end adopted by almost all, but basically with same expectations, through checking excesses of executive power, through precluding that those measures which originated from unlawful actions of the executive take effect, by providing effective protection of rights and freedoms. Constitutional courts were supposed to strengthen the rule of law and to contribute in creating new relations between the state and its citizens. So if we would now go from 1989, in a few years, almost all countries of Central and Eastern Europe adopted and created such constitutional court. There is an interesting example of Poland. Poland already in, if I'm correct, in 1985 created constitutional tribunal, but it has to be said also that almost until 1990 that was very inactive institution. However, there is one socialist country that offers quite different example, and that is former Socialist Federative Republic of Yugoslavia. Why? Because in Yugoslavia already in 1963 constitutional courts were established, both at the level of federation and on the levels of each of 6 republics. And one of those republics is, of course, the Republic of Croatia. Well, we could say that general assessment of constitutional courts' performance in Yugoslavia could be seen in 2 ways. On one hand, these were undoubtedly active institutions. This is what statistics and data show us clearly. But on the other hand, it should be said that, or we could rightfully conclude that these institutions only decided in cases which were of minor political importance. So their constitutional adjudication did not have any significant impact on the political life in Yugoslavia. That's true. But still, from the fact that already from 1963 such institutions existed, we could say that there is a tradition of constitutional adjudication in all countries of former Yugoslavia, now independent states. And really in 1990, 1991, new constitutions of these countries only envisaged constitutional courts as specialized constitutional institutions, autonomous, independent of all state bodies, and exclusively vested with that power to perform judicial or constitutional review, we should say. Taking into consideration my time limit, I would like just to say a few words finally as it regards the case of the Republic of Croatia, because with the adoption of democratic constitution, and that happened in 1990, Croatia was set on new constitutional values, values that differed completely from the principle exercised in the old regime. And special emphasis was given to rule of law, to protection of human rights, and to the Constitutional Court as an institution endowed with the task to uphold fundamental values of constitutional order and to create these new relations between the state and individuals. However, unlike some constitutional courts of new democracies that basically right from the start gained, you could say, reputation of activist institution, it didn't happen with the Constitutional Court of Croatia. Our Constitutional Court for a long time, or for some time, accepted a passive, almost subordinated position towards political branches of government. They were much inclined to that famous political question doctrine. Of course, one has to take into consideration that at that first stage of constitutional development of Croatia, it was significantly influenced by the war, because the war lasted from 1991 to 1995. And during that period, Constitutional Court rather restrained. It mainly focused on defending fundamental constitutional principles, just occasionally showing some inclination toward more activist approach. But what started to change things first was basically internationalization. First, Croatia became member of the Council of Europe, a member state of the European Convention on Human Rights and Fundamental Freedoms. That was in 1998. Then we had a constitutional reform from semi-presidential system. We transferred to the parliamentarian one. So, of course, that constitutional reforms also introduced some new competencies as it regards Constitutional Court, and all of that opened door to a more liberal approach in interpretation of the Constitution. Of course, one very important thing is or happened in 2013, because starting from 2013, the Constitutional Court of the Republic of Croatia has to take into account EU law, because Croatia became EU member state as a last European state that managed to accede to European Union. So finally, assessment of Constitutional Court's performance through the transitional period, it shows that it was a positive, it was a constructive factor of constitutional democracy. Its first years were undoubtedly cumbersome due to different reasons. I've already mentioned wartime circumstances. Of course, there was significant political pressure from the executive. Even constitutional judges had to adapt to new constitutional values. Then, of course, you have the question of capacity of the personnel itself. But still, as time went by, the court undoubtedly managed to strengthen its position in political system and gradually developing its interpretational capacity, occasionally displaying activism in its decisions. The court managed to shape the constitutional landscape and eventually it managed to establish itself as the guardian of the Constitution. Thank you.
Thank you, Peter. Bačić.
Thank you, everyone, for this.
Yeah. So it was indeed very informative discussion on the transition period of the different constitution of the Central and Eastern European from socialist to democratic country. And it is one of the basic feature of any constitution is that the constitution is an organic law. It should change according to the need and necessity if it has to survive for a betterment of the people. And in this regard, I think the transition of those constitutions has catered those needs of the people. And so my question to you is, Peter, in this regard is that does the enhancement of human rights jurisprudence has played an important role in this transition period, or there were some other need because of which the constitution of Eastern European have transited from socialist to a democratic constitution? Which were the factor responsible for this transition, which are very important to understand the contemporary transition of this constitution? Over to you, Peter.
Thank you. As it regards human rights, what I wanted to say that there is an instrument of constitutional complaint. You see, when designing these constitutional adjudication systems in Central and Eastern Europe, many constitution makers decided to adopt a constitutional complaint as a special and last resort of protecting human rights. Of course, in Europe, there is another step. Since all European states are members of Council of Europe and are parties of the European Convention on Human Rights, this European Court of Human Rights that has seat in Strasbourg acts in a way as a federal European Constitutional Court, as a court of last resort when it comes to human rights protection. So yes, when these possibilities open, the citizens overwhelmingly accepted them. But on the other hand, all constitutional courts of these countries then experienced the same problem, because that constitutional complaint became so popular tool that these courts became heavily burdened with cases. So that it is usually said that they fell as victims of their own success. That's what might be said for constitutional complaint. And yes, you were absolutely right as it regards constitution as well as European Convention of Human Rights. It is a living instrument and has to be a living instrument.
So Professor Carlos would like to throw some light on this thing, because sir, your study is also on the European Constitution and Latin. So if you can throw some lights. Sir, you need to unmute yourself.
Okay, yes.
Yes.
Please, Professor, could you repeat me the question, please?
My question was that, as Peter stated, that the few constitutions of Eastern European countries have and Central European countries have transited from socialist constitution to democratic constitution.
No, now I can see a transition, because the last news about, for example, Chile, no, maybe next April, the new constitutional convention elected maybe start to begin a transition to liberal or to a socialist constitution. It's a maybe. Look, that is some kind of crisis, because Chile has economic model a success economic model, but the socialism in Chile makes problems to the government, and maybe Chile becomes to get a socialist constitution. It's a risk to the region. It's a risk to all the region. No? Bolivia, Venezuela, no, Ecuador, no. Maybe the future Colombia, we don't know, and Peru. Now in Peru we have elections, presidential election next April, and maybe some candidates talk about change our constitution, and they think that the future is the Venezuela, Ecuador, and Bolivia written constitutions is the new model. No, that's a problem now. No, that's a problem. No? Because there's not rule of law, and has the a Cuba influence. No, it's a Cuba influence in the region. No, they name it the constitutions of the socialism of 21st century. 21st century, no? Is they name it that. It's curiously that constitution without liberties, constitutions without separation of powers. This is a rare constitution. That's all. Thank you very much.
Now, sir, I have a question to Professor Vijayakumar, sir. Sir, you stated about separation of power, where the Indian courts have been reluctant initially to identify that there is a separation of power. Even if they have identified after Keswan and the Bharti, they make a differentiation that what the separation of power is under the Indian Constitution and US Constitution varies. Probably that might be because of the form of government which we have adopted, the parliamentary and presidential. The degree might vary, I agree to that thing. But my question is that whether in UK, which is a parliamentary form of government with parliamentary supremacy and not a constitutional supremacy. So there are different models of government: presidential form of government, parliamentary form of government with constitutional supremacy, parliamentary form of government with parliamentary supremacy. Whether in such a system also the separation of power would be quine so non to such a system also as well?
Thank you very much for that question. Very interesting. Let me put it this way. The notion parliamentary form of government of the British origin possibly does not exist in England even today, right? So the parliamentary supremacy that it had in 1688 and down the line maybe another century, right? That type of model of parliamentary supremacy or leading to parliamentary arrogance is very peculiar only to the UK constitution. Whereas in all other Commonwealth countries, wherever they have taken the clue of the parliamentary form of government, they have not worked it properly and effectively. The reasons are many, because while the constitution could be copied, the constitutional culture cannot be copied. It differs from place to place, people to people, and there plays what you call it as a very, very important role of constitutional conventions. Even without a written constitution, England is able to survive because of the constitutional conventions, which I think is the oil to an engine, which keeps the machinery going. But whereas in a written constitution, we never, if you go through the Indian constitution categorically, nowhere it mentions that the parliament is supreme. The moment you have enshrined the fundamental rights chapter, part 3 of the constitution, I think parliamentary supremacy goes out through the nearest window. No parliament worth the name can say that they are supreme, that they can do anything they want. But whereas in England they could. That's what many writers said. Parliament can do anything except make a man a woman and a woman a man, right? That much power was given to the British Parliament. That is not the case in India. If at all there is somebody who is supreme, I would rather say that the Constitution is supreme. And therefore, simply saying that parliamentary form of government we have adopted, we have not adopted parliamentary form of government in one sense, right? There were arguments in favor of parliamentary government. Many people in the Constituent Assembly saying that we have lived in the parliamentary form of government for more than 200 years. But let me tell you, we never lived under the parliamentary system of Great Britain even for a single day. As you know that the Governor General, Viceroy, they were all leading to the presidential type of authority, one man's authority, not that parliament was in existence in any sense. So therefore, comparing them historically is very, very important to understand, and looking at the parliament and its power under the written constitution of India, with all the amendments made to the Indian constitution, still I am hopeful that the separation of powers will come in and then check the authority of one over the other and check the authority of all over the rights and liberty of the individuals. I think that is the basic purpose of the constitution, right? And I would appreciate for the Indian readers who would like to read this judgment, Samsher Singh versus State of Punjab, 1973 Supreme Court. It's a constitution bench. It's a 7-judge bench, in fact, and it is a unanimous judgment. 5 judges wrote an independent opinion, and 2 judges, Justice Krishnaya and Justice Bhagavati, writing the concurrent opinion. I think if you read, you will see that there is vast difference between what they wrote as unanimous judgment of 7 judges vis-a-vis the provisions of the Indian Constitution. Thank you.
So now this is the last question to all the 3 of you, and that is carrying further discussion and drawing a constitutional analogy that United, as you sir rightly stated, that it cannot be a primary judicial review of the law passed by the British Parliament because of the supremacy. But my basic question is that after becoming the member of EU, and they have passed the Human Rights Protection Act, which has a non-compatibility clause, so there cannot be a judicial review of primary legislation by the court in United Kingdom, but EU Human Rights Court can struck down that law for the violation of human rights. So my question is that as the judicial review was not specifically stated under the US Constitution, and the court in Mallobury versus Madison presumed as an inherent power, after becoming the member of EU, whether the court in United Kingdom would also can draw the same analogy that now if the supranational court can struck down, why not the national highest court can struck down that law? So whether those power can be inferred by the judiciary in United Kingdom or not?
Who would like to go first?
Oh,
I think.
okay. Sorry. I'll just start, and that will be very shortly. Right, while Dr. Molia was speaking about this, I remembered, if I can remember correctly, it was a famous judge, Lord Denning, who said EU law is like a tide, so you cannot stop it. Yes, we have parliamentary sovereignty, but still, EU law with time will start to show its effects. And I guess that also happened when Human Rights Act by the end of 1990s, if I'm correct, was adopted in UK. That's all, sorry.
Yeah, right.
Well,
yeah, please, Carlos.
Thank you, Professor. Well, in UK, UK hasn't the judicial review. The judicial review born in the States, no, Marbury versus Madison case, no, and UK hasn't constitutional control. The judiciary hasn't make the judicial review because In UK, prevalence the sovereignty of the parliament. No, is the main principle. No, the parliament is sovereignty. No, it's a consequence of the glorious revolution. No, it's a consequence of the glorious revolution. No, in UK. No, and at now, no, it's just Professor Vijayakumar is correct when he said that when he said the professor alone, no, the parliament can do everything except change a man to a woman. This is the alone. And that has a good reason, because it's the natural law. No, it's the core of that form to the core of this phrase is the natural law. No, so the parliament can do many things, but can't not change a man to a woman. But to other things, the parliament is the supreme. Is supreme. The sovereignty is not correct. No, it's more European continent. No, Napoleon. It's Napoleon. It's Napoleon. Napoleon and friends. but the correct way is to think that it's a supreme. Parliament is supreme. Also supreme the constitution. No? But the law say that probably they don't to take the constitution. They want to change it. No? Probably they want to change it. No? But it's main difference to the states. And the last but not least, we need to remember. I need to remember the Bonham case in UK. No, it's the maybe an antecedent, no, of the Marbury versus Mason case in the States. No. Also in the States, judicial review doesn't born in the written constitution. No, it's a judge-made law. It's judge-made law. No? It's interest. And now, judicial review hasn't get a new amendment in the constitution. The judiciary is the owner, no, the principal, no, is owner of this, the owner of the judicial review. In Latin America, we need to put it in the text because it's necessary. No? No, but the first world is other ranking. Other ranking. Sorry, thank you very much.
Yeah.
Over to you, sir.
Thank you. Yeah, I fully agree with Carlos, but let me also mention that some writer after this parliament cannot make a woman a man and a man a woman. Somebody wrote, why not? The parliament can make a law calling all men as she. And all men as all women as he. Even that is possible. I think these are views which people expressed, but I would appreciate if one carefully goes through the judicial decisions, even in England. I think the undercurrents were very clear for the emergence of the doctrine of judicial review, and they call that it will be common law tradition. If it does something, then possibly they would also go to that extent, though they did not use that judicial review power, but they ascertained that they have the power for two reasons, which I think as a student of both political science and law, I understand this in a different perspective. The House of Lords, which was the highest fora in England, was also part of the upper house, the House of Lords. So there was some sort of preview rather than review. So therefore, the laws were tested on the floor of the House to a great extent, whether this is a good law or bad law. That's one way of looking at it. The other question I would like to ask of the students of comparative law Comparative Constitutional Law is, there was a saying that the king can do no wrong till 1947, right? Till 1947. But
Yes.
can anyone say that after 1947, the parliament can do no wrong? I think it's $1 million question. Coming straight away to the question on how the British could not enjoy the power to review, but the European Court of Human Rights did. I think they set aside some of the provisions of the laws passed by the parliament as unconstitutional, particularly the labor relations laws, so on and so forth. That is a price that UK had to pay to be part of that European Union, right? And once you are there, you bequeath your sovereignty or sovereign power to somebody who is regional, and then you are subscribing to the constitution of the Europe, right, of Europe. And I think that is how it worked. My concluding observation on this is, somebody said that the Supreme Court of the US assumed the power of judicial review in Marbury versus Madison. I would like to correct it. It is not assumed the power. It was a necessity. There was a clear-cut violation or a conflict between the provisions of the Constitution and the provision of the American Judiciary Act, right, which was passed by the Congress. And therefore, that conflict needed the restoration or the resolution. And I think John Marshall went in favor of giving the supremacy to the Constitution over the law passed by the Congress. So it was a necessity. And in the necessity, they found out a dictum called judicial review, which I think many countries today enjoy that power of judicial review, sometimes within limits and sometimes over the limits.
Yes,
Exactly.
I agree. Thank you.
Thank you, Professor Vijayakumar sir, Peter Bačić, and Carlos for
Thank you.
enlightening discussion on this. There are many questions which we can discuss, but due to paucity of time, we would end the sessions. And now I would request one of our student, who is the student chairperson of our student body, Tushar, to give vote of thanks. Over to Tushar.
Thank you so much, sir. So a very good evening and good morning to one and all present. It's a matter of immense pride and pleasure for me today to deliver the vote of thanks on this momentous occasion. So it was an absolute honor and privilege to host Professor Dr. Carlos Hakansson, Professor Dr. Peter Bačić, Professor Dr. Vijayakumar. I, Tushar Chaudhary, Student President, NILSA, on behalf of Institute of Law, Nirma University, wholeheartedly extend my sincere thanks to Professor Dr. Vijayakumar for delivering such an insightful and thought-provoking session on the importance of separation of powers to the Constitution. Thank you so much, sir. Next, I extend my sincere thanks to Professor Dr. Carlos Hakansson for delivering an insightful lecture on the topic European and Latin American constitutions. Next, I extend my thanks to Professor Dr. Petar Bačić on delivering a thought-provoking session on the topic constitutionalism of rule of law in European new democracies and rule of constitution courts. Thank you so much, sir. And I firmly believe that this session has left a great impact on all the audience. Further, I extend a heartfelt thanks to our respected Professor Dr. Purvi Pokhriyal ma'am, Director and Dean, Institute of Law, Nirma University, for organizing this International Teaching Month for the students, which has served as a platform for knowledge sharing by distinguished persons from different walks of life. Also, I would like to acknowledge the presence and participation of Professor Dr. Stephen Barnes for his constant support and motivation. Thank you so much, sir, for attending the session. Further, I would like to extend my thanks to Dr. Takesh Molia, sir, for moderating the session and ensuring a streamlined conduction of this session. Next, I'd like to thank the International Teaching Month team, Professor Shreya Srivastav, ma'am, Head International Office, ILNU, Mr. Gagandeep Khanduja, Assistant Registrar, ILNU, and all the members of our administrative staff and the technical team for their constant support behind this whole event. Last but not the least, a big thanks to all the faculties and students of Institute of Law for their patient listening, cooperation, and active participation throughout this whole event to ensure the success of this session. So it was an absolute pleasure to host all of you all. Have a wonderful day and thank you so much.
Thank you.
Thank you. Thank you very much.
Thank you, sir. Thank you so much. Thank you.
Thank you so much.
Thank
Thank
you.
you.